Hello and welcome to episode 16 of The Legal Scoop, our web series here at LOMAD where we talk about recent notable wins by our attorneys. I'm Brendan Shannon. I'm joined today by my colleague Neil Diegelman, who's going to talk about an interesting fraud win that he had recently. Say hello, Neil.
Hi, thanks, Brendan. Thanks for having me on.
Thank you for being here. So I understand that you had a pretty juicy fraud claim with extensive surveillance. So why don't you just go ahead and give us some of the background, like the basic facts.
Great, yeah. So we had a claimant who was injured, remained at work, then went out of work for the employer of record for a closed period of time from November to April 22 to 23, and subsequently returned back to the employer of record thereafter. He also owned a bar restaurant, and we obtained surveillance of the claimant at that bar restaurant. Now, he wasn't serving drinks or serving tables making food, but as the owner, he was certainly seen performing activities that you would assume a general manager would be performing and doing. We raised the issue of fraud. We went to the hearing, took claimant's testimony. Claimant testified briefly in a sense that when he stopped working for the employer of record, he stopped working at his bar restaurant, that he would occasionally go to the bar restaurant to have meals with his father or watch sporting events, but otherwise did not engage in any employment activity there. The claimant denied any work activities outside of his employer of record and disclosing that he had the bar restaurant. Mm-hmm. So then we submitted the surveillance evidence that was extensive, like you said. A lot of it showed the claimant just sitting in a car in a parking lot right connected with the bar restaurant, but there was significant evidence of him handing out what appeared to be parking passes. He's performing some work fixing lights, awnings, signs at the business. He's also doing something along the lines with the parking at that parking lot again. So things that look like work activities that one would expect to be paid for. We deposed the doctors. The doctors interestingly maintained that the activities they saw in the surveillance weren't necessarily inconsistent, but they wouldn't necessarily recommend that the claimant participate in those type of activities. Mm-hmm. We go to the final written summations, and our position was that the claimant was not only committing malingering fraud by misrepresenting his capabilities to the doctors, but also committing working fraud as he was seen performing what we would consider work activities at his place of his bar restaurant.
Right.
The judge reviewed all this surveillance and evidence and came to the conclusion that the claimant was engaging in multiple occasions with exaggerations than what was presented to the treating physicians and our IME doctor. The claimant was seen chipping ice, shoveling ice, bending, stooping, lifting a table over a car, all with the intent to defraud the carrier. The judge also went on to state that the claimant's activities would appear to be what one would consider would be work or actions that would be considered work for pay. And therefore, the judge found that there was a mandatory penalty for the period of lost time claimed, again from that November to April, and then a lifetime mandatory or lifetime discretionary ban on future indemnity awards.
Wow. You're right. I mean, he's doing these things presumably to benefit his bar restaurant, so I think that's a reasonable conclusion to come to. My one question is, in the medical reports, did he deny working?
Oh, absolutely. Through and through denied working. All the way through, which is also interesting, and I'm glad you brought that up, because in the reports it stated that a exacerbating factor was working, and that during depositions I hammered the doctors on how could that be an exacerbating symptom if the claimant was out of work.
Right, yeah. Well, Neil, that's a great win, and I mean, it sounds like you had to go through quite a bit of surveillance to get there, so congratulations on that one.
Great. I'm very happy with the outcome of this. It's a good fought case that the facts came together with great legal work here at LOMAD and good work with our client.
There you have it. So if you have a claimant that you suspect is potentially working while out on comp, you might want to consider surveillance and giving us a call. That wraps up today's episode of The Legal Scoop. If you want to see more of our video content, we also have The Daily Grind with Melanie Daly. We release a monthly newsletter as well. You can subscribe to be a VIP by going to our website if you're interested in something like that. We'll see you next month, hopefully with another notable win.
Thank you.